Of the Special Tribunal against the Estate Police Association.
Mr. Rowe.
Please, Your Lordship, I appear in this appeal for the appellant, and my learned friends, Mr. Douglas L. Mendez, Senior Counsel, Mr. Anthony Bullock, and Mr. Clay Hackett appear for the respondent. My Lord, in the light of the way in which the issues have emerged from the parties' printed cases, there are, I would suggest, essentially two issues in the appeal, and it seems to me on reflection logical to state them in this order. First, were the Special Tribunal and the High Court right to hold that it was fatal to the association that no branch board had been established, or were the Court of Appeal right to say that it was not fatal to the association's case?
Should we call that the branch point?
I'm sorry?
Should we call that the branch?
The branch point, quite. And secondly, and I put it this way in the light of what's said in my learned friend's case, should the board say anything, and if so, what should the board say, about the circumstances in which judicial review lies against a decision of the Special Tribunal?
And we'll call that the judicial review point.
The judicial review point.
Mr. Rowe, it's our understanding, having read the papers and your very helpful written cases, for which we're most grateful, that you're not submitting that any proper outcome of the judicial review point could enable you to succeed in this appeal against the Court of Appeal. I think what you're inviting us to do is to take a broader view and try and give guidance on just what limits to the judicial review jurisdiction there are or may be in relation to the work of this tribunal.
Yes.
You say, and we note, that there aren't sort of disputed issues of fact which go to it, but you also accept, as must be the case, that this broader aspect of the matter was not looked at by the Court of Appeal.
No.
So that we don't have the benefit of the Court of Appeal's views on the subject.
No.
Now, our provisional view is that this is a case par excellence where the board ought to have regard to the views of the local top court, in this case the Court of Appeal.
Yes.
And in particular to the views of that court after that court itself had heard an argument about the matter, so that its views on the point are refined by adversarial debate.
Yes.
Which always produces better outcomes. Therefore, our fairly firm provisional view is that we ought not to go down that road. We'll give you a short time, if you want to try and persuade us otherwise, beyond what you've already said in your written case that we've read. But we really think that needs to be looked at the outset to see just how much there is left of this appeal. Yes.
Well, Lord, I'm as ever very grateful for the indication of the board's provisional view. It's much more helpful.
It's not a view about the merits of the point; it's a view about whether we should be entertaining it at all.
I understand that, and I will keep that point firmly in mind when I seek to address your lordships on that issue.
It's not even raised in your grounds of appeal, is it?
No. Well, the original.
The original ground was that it was an all or nothing.
Yes, that's the unusual aspect of the. I mean, there are a number of unusual aspects of this case.
Just to keep
that's one of them.
Matters in order. I know you want to take the branch point first, but we would like to hear anything further you want to say about why we should entertain the judicial review point at all.
Very well. Well, whenever counsel says I'll deal with it in this order, that's always subject to the court's right to say no, you won't. So I shall be guided.
We're not inviting a lengthy deviation.
No, I appreciate that, my lord.
Understand.
I ought to, of course, I would at once also, my lord, to acknowledge another unusual aspect of the matter, and that is, of course, that the tribunal against whom the claim has been brought is participating in the appeal.
Well, that is something that raises a bit of an eyebrow, Mr. Rose, you could imagine.
Yes, well, I anticipated that it would, and of course it's unusual because, of course, as your lordships know, the usual convention is that the tribunal or court, indeed, against whose decisions a challenge is brought takes no part other than sometimes to assist the reviewing court with explanations as to its reasoning rather than entering the fray. But nevertheless, it's something that went uncommented upon by the High Court and the Court of Appeal, so far as I can discern, which was prepared to entertain the matter on that basis. But it does.
The decision was taken by your client to actively pursue an appeal to the Privy Council, which adds another dimension to it.
Well, my lord,
putting the other party to additional expense
and delay.
Well, my lord, my lady, that's entirely right. The Special Tribunal's reason for doing that was in order to seek clarification from the board in the exercise of the right of appeal to the Privy Council.
Grounds of appeal. It was put the Court of Appeal are utterly wrong on the point.
Yes. Well, my lord,
we are now actively defending our own decision.
As I say,
ask the Court of Appeal for submissions on the point if we're going to go down this road.
Well, as I say, my lord, I accept it. It's what. Yes, it's why. I noticed in my learned friend's case on the branch board point, I noticed that there's comment that the way I put it in my written case is less than robust in criticisms, but it's precisely because it seemed to me that in these circumstances the proper course was to lay out for the benefit of this board what the competing arguments were, rather than go hell for leather seeking to uphold my own client's decision against all challenges. So that's why we are in this situation. And so far as the point about judicial review is concerned and the jurisdiction, the reason it's arisen this way is, as your lordships will have seen from the history of the case and have already put to me, at first instance and in the Court of Appeal, the point being taken was simply that the Special Tribunal is to be assimilated to the position of a superior court of record, i.e. the industrial court, which is, on the face of the statute, declared to be a superior court. And therefore, it followed, so the argument ran in the High Court and the Court of Appeal, that it was immune from judicial review, full stop. Now
that's not a very attractive argument to litigate either for a tribunal, that we're going to be pursuing through the appellate courts at the expense of the other party, an argument that our decisions are immune to any form of judicial review.
Well, my lord, the other... Certainly, so far as the position before the board is concerned, I note that my learned friends say in their case that their client has been harassed by the need to deal with these points. But in fact, they actually what they then do is far from appearing harassed. They appear to enter into the detail of the arguments to quite a substantial extent. They could have said. This is an academic point. Well, they could have said this is an academic point, given that...
Well, there's a risk. There's a risk if you pin your colours to that mast.
Well, I'm not sure there would have been in this case, actually, because I think we agree that the indications that we look for from the board about judicial review, as to which I've heard your lordship's provisional view and we'll deal with in a moment, are not indications which alter the outcome of the branch point.
Well, they may be concerned about other claims they may have in the future if you're going to be allowed to start arguing that the judicial review power is very limited.
Well, can I come straight to the point about the and the reason that the Special Tribunal has taken the view that it makes these submissions and why it's an important point.
The key question for us, Mr. Rowe, is not so much the internal thinking of the tribunal,
of course,
but why it would be right for this court to embark upon this, I think you accept, technically academic exercise without having heard the views of the appellate court within the jurisdiction itself given after argument in that court.
Yes. My lord, can I, in answering that question, seek to make clear what we the way we put it, and we put it. That's why we put it in the printed case in terms of the board indicating its view as to what generally would be expected to be the position, rather than inviting the board to lay down in absolute terms what the position is. The difficulty is that at the moment, and this is the consequence of the way the arguments occurred in the courts below, but to use the cliche, we are where we are, that the difficulty is that what you had in the courts below as a straight argument, is there or is there not a jurisdiction to entertain judicial review proceedings against the Special Tribunal's decisions. The Court of Appeal has simply said, yes, there is such a jurisdiction. And if one simply left it there and said no more, then that would leave entirely open the question as to whether there are or could be any limits on that jurisdiction.
It would arise if it had to arise in a case which on its facts,
Yes.
facts about the litigation and the dispute, calls that question to arise.
Yes.
That's
Well,
how litigation works, isn't it?
it is ordinarily, my lord, it is. But in public law cases, of course, as my learned friends acknowledge in their very helpful and thorough review of the authorities on this in their case, in public law cases, there is a jurisdiction in the appellate court sometimes to entertain academic points. And what I mean in the present context, I suppose what I mean in the present context, and the core of it is really this, that it would be unfortunate if the board gave, in its decision on this appeal, the impression that it certainly it would be unfortunate if it gave the impression it decided that there was an unlimited judicial review jurisdiction. I can entirely see in the light of your lordship's provisional indication.
The question is arguable.
No, I can entirely see in the light of your lordship's indication that it might be why the board might be reluctant to go as far as I've suggested in our case. I entirely appreciate
you
that.
want us to decide it if we decide it in your favour, but not decide it if we're going to decide it against you?
I don't think that's entirely fair criticism, my lady.
Being asked to decide any judicial viewpoint in the sense that you no longer submit that you have any point which could lead to the Court of Appeal's decision that this decision was amenable to judicial review being overturned.
I agree.
So it's not us adding a sentence to a judgment, it's us whether we trespass into that area at all.
Yes.
And you're saying if we do trespass into that area, it's just to express a general view,
Well,
not to decide the point. Is that right?
Well, inevitably, on what is a put at its highest, I think I have to accept our case invites this board to express. I think we've described it as a view, but in the way of these things, when at this level of jurisdiction, when a view is expressed, it comes pretty close to being a decision. The doctrine of stare decisis perhaps tends to fray a little when one gets to this level, as one can see from the law of dishonesty, for example, in criminal cases, which was reversed in a civil case, effectively, by the Supreme Court. But as I say, the central point is that the concern is one should not be able to walk away from a perusal of the judgment in this appeal on the matter which is actually before the court, the branch point, with any impression that the board has given its imprimatur to the suggestion that there is an untrammeled right of judicial review in this case.
I'm sure we can explain why it is, if that's our decision. We aren't dealing with the judicial review.
Yes. Now, in the printed case, we sought from the board an indication of its view, not essentially, yes, for the purposes of contributing to the thinking of the Court of Appeal and indeed the High Court next time this point arises in Trinidad and Tobago. It simply is a matter of practicality because these things take so long to go through the system. It seemed to us that it might be helpful to invite the board, if there was an appetite to do it, to say something about the parameters, at least, of the argument that might arise.
The choice is between there being an untrammeled right of judicial review and a judicial review which is limited as if it were the right of appeal from the industrial court to the Court of Appeal on sort of limited grounds, it being accepted that actually there is no right of appeal at all from the Special Tribunal to the Court of Appeal. Is that right?
Yes.
But if we accede to your invitation to express a view, then we have to express a view that one or other of those options is the correct one, don't we?
Well,
but you would, that's why I said that you seem to be saying, well, please express a view if your view is that it's limited, but if you're going to express a view that it's an untrammeled right of judicial review, then we prefer you didn't.
Well, I take your ladyship's point, and I entirely accept it would be it's not a very attractive submission to put it quite that way. That I accept. But this comes back partly to the point, the point about the unusual nature of the proceedings, with the special tribunal itself taking part.
That seems to me to make it even less desirable for the board to start expressing views.
Well, my lord, our concern is simply that there should not be missed an opportunity for this point, which is plainly a point which is debatable. In my submission, I mean, it's certainly. Your lordships have seen the arguments that we advance in the case in favour of the limited right of judicial review account of things, based on the insight that was expressed, for example, by Mr. Justice Fordham in the Exolum case about the judicial review not necessarily being all or nothing. And it seemed to us that it would be, if there was an appetite to do so, it would be helpful for the board to engage with that and make at least some observations about it. But if there isn't, then so be it.
Thank you very much, Mr. Rowe. Well, Mr. Rowe, I'm afraid the appetite is lacking.
So I discern, my lord. So that's that.
I'd like you to go back as your only point to the branch point.
Very well.
And we anticipate that this can be dealt with, assuming, as you should do, that we've read the underlying materials really quite shortly.
I entirely accept that, my lord. I don't intend to detain your lordships and your ladyships for a moment longer than I need to on this point.
I suppose I should have paused to ask your opponents whether they're desperate that we should discover an appetite, but I rather picked up from the general thrust of your case that you're not.
I don't think that we should get into the habit of asking a court just to give us an advisory opinion.
Yeah. Thank you very much.
So, my lords and my ladies, on the branch point, it's probably helpful just to look briefly at the scheme of the legislation that we're concerned with, and some of that will involve looking briefly, at least, at the questions that would have been relevant if the appetite had been there to consider the whole of the judicial review point, because one needs to set the decision about branch boards in context and just see what it was that the special tribunal were doing. But I'll take that as briefly as I can. Your lordships and your ladyships will have seen that the scheme of the Industrial Relations Act is to set up the Industrial Relations Court, or the Industrial Court, rather. And can we pick it up, my lord, at page 690 in the electronic bundle?
Yeah. That's the opening page of the Act.
That's the opening page of the Act, yes. There's a definition, a couple of definitions that are relevant in section 2. Page 691, essential services, towards the bottom of that page, means the service is set out in the second schedule. And one can jump to the second schedule, which is at page 792, I think. I got that right. No, I haven't. Sorry. Well, I can take it more quickly than trying to find the correct reference, because it's in my learned friend's case, I think, that they explain, they list. I mean, I don't need to show it to the board. It's they list what the
Schedule 2 we're looking for.
Yes. Sorry, 762. That's why.
That sounds right.
That's better. Yeah. Sorry, it was just me misreading my note. Essential services: electricity service, water and sewerage, internal telephone, external communications, fire, health, hospital, etc. And the scheme of the Act, as we'll see, is that essential services are dealt with separately.
It doesn't. So that the essential services doesn't cover these estate companies.
No, it doesn't. There are essentially three categories. Well, I can leave the word essentially out. It's confusing. There are three categories that we're concerned with. There are essential services that are those things which don't include the estates police. There are people in the situation of the estates police who are dealt with by the special tribunal, and there are others. And we get that because if we look at 694, we can see the definition of worker.
So those doing essential services are also workers?
Yes. Worker is defined very broadly in the definition section at 694, but there's then a carve-out at section 2, subsection 3, which is on page 695. For the purposes of this Act, no person shall be regarded as a worker if he is, and then there are various things listed, the second of which is a member of the
police service.
Yes, defence force, ancillary force at the police, fire or prison service, or of the police service of any municipality, or a person who is employed as a rural constable, or, and that's the important point for our case, an estate constable. Then we see, my Lord, at section 4, page 697, the establishment of the industrial court. And in the light of our earlier discussion, I needn't linger on the Superior Court of Record, etc., etc. We can simply see that there is a court. It has its various divisions, 2B, General Services Division and Essential Services Division. And then at subsection 2, capital C, the special tribunal established by the Civil Service Act and referred to in the Police Service Act, the Fire Service Act, the Prison Service Act, the Education Act, the Supplemental Police Act, which is our Act, and the Central Bank Act shall consist of the chairman of the Essential Services Division and 2 other members of that division selected by him, and shall hear and determine disputes arising in the civil service. That word disputes is important. The police service, the fire service, the prison service, and so on. The supplemental police of relevance to us, as if those disputes arose in essential services.
Yes.
And then we jump for a moment to the Civil Service Act. That's at page 667.
667.
667. That just shows you that that's how it's established under that Act, consisting of the chairman of the Essential Services Division and so on, but the Constitution doesn't much matter for present purposes in the light of our discussion earlier. But subsection 3, the Special Tribunal shall hear and determine any dispute referred to it under section 20 and shall make an award on the dispute. We can leave aside that reference. That reference, actually, I needn't have read that out. Actually, that's disputes in the civil service,
yeah,
which we're not concerned with. So what we are concerned with are of course, disputes in connection with the estates police, and starting point there is to look at the Supplemental Police Act. That's in the authorities bundle at page 847. And the relevant part of that we see at 851 in the definition section. Dispute means any dispute or difference between employers and estate constables connected with the employment or non-employment or with the terms and conditions of employment of any estate constable, but does not include any dispute with respect to the exercise by any person of any power in relation to questions of discipline, promotion or transfer conferred on him by this Act or by regulations made thereunder. And then, skipping through that Act, we get to, well, not skipping much actually, we get to section 3, which I want to just draw to your attention. That establishes the estate police and the rural police. There shall be established.
What are these estate police? Do they guard public premises or the premises of public bodies, or what are they actually doing?
My lady, I'll be corrected, I'm sure, by those more knowledgeable about local conditions than I am if I get this wrong, but as I understand it, they don't necessarily guard only public property. They can guard private property, but in doing so they're regulated to a significant extent, just as if they were full-time members of the police.
Well, all those the subject of these proceedings were guarding private property.
Yes. Yeah. So it's a hybrid, unknown, I think, in most jurisdictions that apply the common law, but extant in Trinidad and Tobago. But the fact that they are police officers is, of course, important, because that's what gives rise to this whole special mechanism for dealing with disputes that those officers collectively, as I'll come on to explain, have with their employers.
4.2 says it shall comprise constables as are employed on any estate.
Yes.
For maintenance of order.
Yes. I don't think that means that anybody who you employ to guard your estate becomes an officer, because the person still has to be a constable.
Yes.
But it allows for that slightly hybrid.
Well, both the estate and constable are defined on the previous page.
Exactly. Yes.
But these estate constables, they work full-time guarding this bank, then, as far as you know.
Well,
so it's not like with our police force, if they go and police a football match.
No.
Which
No,
they
that's
sometimes do, and they get paid by the football teams.
Well, that's why they're being paid. They're being paid by the bank. That's their grievance in this case, isn't it?
Yes. For the purposes of being paid, they're being paid by the bank, but they're not, and they are at least to some extent employed by the bank.
Yeah.
But under this hybrid regime, which doesn't import all the usual incidents of employment, because they're constables. It's an unusual thing from the perspective of probably most of the rest of the common law jurisdictions, but that seems to be how it works. And then if we go on through the Act, some of the pages are omitted from the copy in the record, but we can pick it up at 853, which is section 36. Except as hereinafter provided, an estate constable shall not be a member of a prohibited association. And there's provisions about that.
And that includes.
That would be trade unions. Yes, that's the obvious import. Is they're not to be part of trade unions. And then at 38, we get into the most relevant territory for our case. For the purpose of enabling constables of the estate police to consider and subject to subsection 2 to bring to the notice of their employers matters which trade unions are competent to bring to the notice of employers of members of the unions. So this is Parliament filling the gap that it's created by saying that they can't be members of trade unions. There shall be established an organisation to be called the Estate Police Association, which shall act through branch boards, and a central committee as provided by rules made under this Act. The Estate Police Association shall have the sole right to make representations as in this subsection mentioned. And then the carve-out in subsection 2 is they can't make representations about questions of discipline, promotion or transfer affecting individuals.
So it's terms and conditions and pay and the like.
Yes.
Yeah.
Yeah. And subsection 3, the Estate Police Association shall be entirely independent of and unassociated with anybody outside the Estate Police. Section 39, 1, the Minister may make rules for the constitution and governance of the Estate Police Association and as to any matter appertaining to the association. Subsection 2, the Estate Police Association rules formally contained in a schedule to this Act, this is obviously an amended provision, shall be deemed to be made under subsection 1 and may be amended or revoked under that subsection. We'll come in a moment to those rules. And then Section 40, a dispute which arises among estate constables or between estate constables and an employer may, if not otherwise determined, be reported by the employer or by the Estate Police Association to the Minister of Labour, and on the report being made, the proceedings on the dispute and all matters and things incidental and ancillary thereto shall be had and taken mutatis mutandis in the same manner as proceedings on a trade dispute under Part 5 of the Industrial Relations Act, and applying, and then there are some provisions substituting words or requiring you to read words in Part 5 so as to apply to this sort of dispute. Now that reference back to Part 5 of the Industrial Relations Act is of course to those provisions of the Industrial Relations Act which cater for disputes between people who are members of trade unions and their employers. And it's relevant to note that this is a collective procedure. This doesn't give an individual right in the way that some jurisdictions have individual rights to complain of unfair dismissal, for example. It's a collective procedure. Disputes can be reported either by the employer or by the Estate Police Association to the Minister of Labour.
So in this case there was then a referral. Where does that fit into this procedure?
Well, I think for that one needs to look probably briefly at Part 5 of the Industrial Relations Act. That's at page 730. That starts at page 734. Section 51. As your lordships and your ladyship will see, subject to this section, any trade dispute not otherwise determined or resolved may be reported to the Minister only by the employer, the recognised majority union, or in the provisions for what happens if there isn't a recognised majority union. And subject to sections 11b and 19, such persons only shall, for all the purposes of this Act, be treated respectively as parties to a dispute. And there are various provisions in Part 5 about how this is all to work. I think for our purposes, if I've got this right, the most important provision is that which we find in Section 59, which is on page 739. Subsection 2, where the unresolved dispute concerns the application to any worker of existing terms and conditions of employment, or the denial of any right applicable to any worker in respect of his employment, or the dismissal, employment, non-employment, suspension from employment, refusal to employ, re-employment, or reinstatement of any worker. Either party to the dispute may make application to, or the Minister may refer the matter to, the court for the determination of the dispute. So that seems to be the provision that caters, amongst other things, as we've seen, for dismissal. The regime, therefore, being that either party can refer may make application to, or the Minister may refer the matter to, the court for the determination of.
So that's either a direct application by the party or the Minister referring the matter?
That appears to be that's what happens there, yes.
And what happened here? Yes. The Minister referred it, did he?
The Minister referred in the present case, yes.
But with these provisions which depend on there being a trade union and which are then applied mutatis mutandis, is there a similar thing about there needing to be a branch or not?
Well, that's the very thing that we're coming on to look at, my lady, and the special tribunal essentially said yes, and the argument is really as to whether they're right about that, at least whether one should.
Well, isn't the equivalent in the Estates Police Association itself? That's
certainly the equivalent of the trade union.
And
yes.
It acts through the Central Committee and a branch, if there is one.
Well, that's
the question.
That's the way the Court of Appeal put it.
Well, I think Lady Rose was asking whether there's any counterpart for trade unions to branches that having. To
Having to be.
Forgive me, I'm being obtuse by not understanding your question. I don't think so. I mean, I
so there's
confess
nothing
not to have scoured it with that question in mind, but I don't think there is.
Well, it might be quite important.
Yes, it might be.
If there's no provision that says a trade union must act through a branch, then why should there be a need for the EPA to act through a branch? That's my question, really.
Yes. Well, I confess I can't on my feet give an unequivocal answer to that question. I don't think there is any provision requiring a trade union to act through a branch, but I can certainly have a look at that point after hearing if that would assist.
By you pointing us helpfully to section 59.2, which I think you said, well, it can be a direct claim by the individual.
Well, I'm not sure about that. Either party to the dispute.
Yeah, the parties to the dispute are the employer and the trade union.
Yeah.
Yes.
That was in section 51.
Yeah.
Yes. So I think if I agreed to a member of the board suggesting maybe there was a direct right, I was wrong to do so because,
Yes.
as Lady Simpson points out,
the argument here is not, as I understand it, that the association as a claimant was not entitled to bring a claim because it wasn't bringing one. It's that it was never entitled to report the matter to the minister in the first place. Is that how it kicks in?
well, that's
And therefore, the minister, then it's argued because of that the minister's reference is somehow invalid.
well. We'll see in a moment how, admittedly rather briefly, the special tribunal dealt with it in their decision. But I think the argument essentially, is, as I understand it, is that the whole action, if I can use that term loosely, is improperly constituted if there isn't a branch board to set the thing in motion in the first place.
Yeah, but I'm just asking
that,
why, what the step in that reasoning is. And
well, because
is it because of the provision we've seen requiring a report to put it in motion, or is there some other reason?
it's because of the provision in to go back to the Supplemental Police Act, if I may, about the way in which the supplemental, the association rather, is to act.
What's section 38?
Section 38.
Yes.
It's the provision which shall act through branch boards and a central committee as provided by rules made under this Act.
Sorry, can you remind me of the page number?
Yes, it's 853.
I know, but what's the act here that's said not to be an act of the association?
Manuel, I don't think that the reasoning of the special tribunal in its decision goes so far as to identify a direct answer to that question. By implication, if the special tribunal is right that the association can't act other than through branch boards, then that must apply to all of the process, from the initial referral to the minister all the way through to its then pressing its case before the special tribunal.
So how does it? So this works by the EPA. Suppose there is a branch. The branch says to the minister, "There's this dispute. We can't come to any kind of resolution. Can you please refer this to the special tribunal?" The minister then refers it to the special tribunal. Does the minister then sort of drop out and leave it to be argued before the special tribunal between the EPA and the employer then?
As I understand it, yes. Yes.
And 38.1 in its literal terms is only about bringing to their employers matters which unions are competent to bring to the notice of employers and members of the unions. And the sole right to make representations, as in this subsection mentioned, is that sort of representations. And that's a stage before you go to the minister, as I understand it, because you first go and say something to your employer, and although these aren't employees in the sense they do have employers, and if you're not happy with what you get from the employer, then you probably go to the minister.
Yes. Well, it's
Under section 40.
yes.
There's nothing about it having to be the branch.
I agree. Section 40 says nothing about that. Section 30, just to answer Lordship's question, Section 30, what is Section 38 doing? Of course, the side note tells us it's about its constitution of the Estate Police Association. And although it goes on at the end to make provision in the last sentence about what the Estate Police Association has the sole right to do. The earlier part of the subsection, in other words, the first sentence, is really about constituting the body in the first place.
It's not suggested that the association was never constituted.
No, it's not suggested it wasn't constituted, but what impressed the Special Tribunal was were the words "which shall act through branch boards."
Yeah, and they to ignore the following words.
In the process of in the process of constituting the State Police Association, if one breaks the sentence down, the main clause doesn't start until there shall be established. Of course, there's a subordinate clause telling you why it's to be established. The main clause is there shall be established an organisation to be called the State Police Association, and the first thing that Parliament then says is which shall act through branch boards. The comma's a little odd there because it's not quite clear what the effect of that is, but it may be which it could. One can see the reading, I suppose, which shall act through branch. Just ignore the comma, which shall act through branch boards and the central committee.
Well, either you must ignore the comma or you put in another one after central committee, then you have one or the other.
Yes.
But your case is that because it says there that it has to act through branch boards, then whenever it talks about the EPA acting, such as in section 40, one effectively has to read in the words via branch board.
But not read in central committee.
Well, that depends how depends how one reads section 38. What the Special Tribunal thought was that the key provision was shall act through branch boards.
Well, what's the committee doing then?
Well, it established that what this is establishing on this argument. This section is establishing the organisation and establishing its central committee. Can I just so I'm not seeking to make submissions on the basis of having shown you some but not all of the material. Can I just take your lordships and ladyships to the rest of it, and that is in particular to the rules, which we can find in one moment. Just so I'm clear,
is the suggested interpretation that what's being established are two different things? Is the State Police Association, which will act through branch boards, and there's also being established a central committee. Is that the suggestion? So that.
Well, that could be a reading of this section. I mean, I can put it no higher than that. I'm conscious of my sort of quasi-amicus curiae role that I'm.
Well, it's difficult. It just points out the difficulty when a tribunal goes beyond the reasons that it's given and its judgment for.
Yes. The Central Committee is is an organ of the EPA, isn't it? It's not just something completely separate.
Yeah.
Yes, it is.
Exactly.
Can I, if I can take the board to what the rules say, then we can may perhaps.
We bear in mind that the rules were originally a schedule for the Act itself, I think, don't we? And now they've escaped being scheduled, but they're still.
Yes, I don't know whether that makes any difference to the.
No, it's just that the Act and the rules probably need to be read together.
Oh, absolutely, yes. Well, but I think I would accept that would be the case, however it had been set up, whether it was part of the Act or not. The rules you can find at 669. Rules cited as the Estate Police Association rules. Rule 2: every constable for the time being of the Estate Police shall be eligible for membership of the association, and the association shall act through branch boards and a central committee as is hereinafter provided. Estate constables employed on the same estate, Rule 3, and estate constables employed by a protective service agency may form a branch of the association. For each branch of the association formed under Rule 3, there should be constituted a branch board.
So that suggests the shall act applies to branch boards and central committee, doesn't it? That we saw in section 38.
Yes, that suggests that it's conjunctive, so the association shall act through branch boards and a central committee.
So it's not establish the branch board and then separately then?
I think I'd have to accept that, my lady, yes. That would certainly tell strongly in favour of...
The committee is made up of delegates from each branch board.
Yes, I think that's how it works. If one follows it through, you get Rule 6 saying that, well, Rule 5, as we've seen, saying there's the 5 members could go on the branch board. 6 is right to vote. 8 is about 8 is then what happens. Members of each branch board shall at the annual meeting elect from among their number 2 delegates to the central committee.
It's just moving.
I haven't quite got in my head, apart from Rule 3, how members or estate constables employed on the same estate do actually form the branch. Do they meet together and decide by a bare majority that we will form the branch? And then all these rules about what the branch has to consist of kick in at 5?
Well, that may be right.
Or actually, no, you've got to go through 4. They form a branch, and then there shall be constituted a branch board, and it tells you how you set the board up. What it doesn't really tell you is how you set the branch up.
Yes. Could I just check before we go on, my lord, whether Lady Simler's technical problems have been sorted out or
I'm so
not?
sorry.
No, not at all, but I don't.
Thank
I don't want to be making submissions that Ladyship can't follow because the computer's broken.
Yes, I'm fine. Sorry, I missed that last bit.
Not at all. I was just being asked about the way in which the branch is formed. If I've understood Lordship's question correctly, it doesn't go further than simply to say that they may form a branch. Yes. Doesn't explain how they do it.
How they actually do it.
No, it doesn't tell you how they do it. No, yes, it clearly contemplates that because the estate police, the estate police association is an association for all estate police.
Yeah.
So there may be state police who have nothing to do with the estate police in our case on quite the other end of the country.
And the definition of estate proceeds on the rather odd basis that actually all the estates shall be deemed to be one estate for the purposes of this Act, though I suspect that this must be an area where it's otherwise provided.
Yes. There
may be many hundreds of members of a particular branch, but the board has only got 5 members.
Yes, or more if actually more under Rule 5(2).
Yes.
You have 5 in any event, and then if you get more than 50.
Right. So the branch and the branch board are different things.
Yes.
And Rule 16 says that they may, both the branch and the central committee, regulate their own procedures, including appointing subcommittees.
Yes.
And what does the word member mean in Rule 5(1)? Do the branch board have to consist of people who are estate police employed on the same estate?
By implication, I would have thought probably yes, because everybody employed on the same estate may form a branch.
Yeah.
So the people guarding Blackacre can form the Blackacre branch.
Isn't it that there must be at least 5 people employed on the same estate? And if, let's say, 3 of them think there should be a branch board and 2 think there shouldn't, nonetheless, all 5 have to go on the branch board under 5.
Well, your Lordship is probably jumping ahead to the composition of the board. The first question is, should there be a branch?
Yeah. Well, sorry, you're quite right. Let's say by a 3-2 majority they think there should be a branch. Then there has to be a branch board, and that must consist of all 5 of them.
Well, the rulemaker has worked on the assumption that these sort of problems aren't going to arise because there are bound to be enough people to mean that the branch board can have at least 5 members. What the answer is in a case where, say, there are only 3, or suppose there are, or to take your Lordship for example, there are only 5, but then only 3 of them want to form a branch at all.
Now,
then that wouldn't be able to be constituted as a branch board.
These were working at the premises of different branches of the same bank, were they?
In our case?
Yes.
Yes, I think
So how do you divide the premises of the bank up into one or more estates to understand how a branch of these people would work?
Well, they could...
Or could work?
I mean, I would have thought that employed on the same estate doesn't have to cover just geographically people employed in a particular town. It could one could treat the different branches of the bank different.
Being one estate.
The different premises.
Let's avoid the word branch. As different premises of the bank as being one estate.
Yes, I mean that would be because they're all presumably engaged on the same terms and conditions.
Yes, it would make sense, Melody, precisely.
And it is common to refer to, we talk about the Crown estate as being all the land which is owned.
Yes, that's true. That's true.
Court estate is, yeah. But what it could have said that all the estate constables employed on the same estate constitute a branch of the association, in which case that would be a sort of an automatic thing. They just would be a branch.
Yes.
But it does seem to envisage in Rule 3 a sort of conscious act of forming a branch rather than simply just being a branch.
Yes.
By virtue of being estate constables in the same estate.
Yes, it precisely.
And then they send two people to be part of the central committee, but we assume that there must be branches. Is that right? For there to be, because there's a central committee, so presumably
yes,
there are branches, but just not relevant, none that are...
This is all permissive. This is not like... It's not like... I mean, there are, of course, membership institutions which are obligatory. Mm. Like when you arrive at university and you're told that you're a member of the student union, whether you like it or not. I mean, that's just that's the setup that's there. This isn't like that. This is permissive. So it would be perfectly possible for a group of estate constables. I don't suppose they would do this in practice, but it would be perfectly possible for them to decide they weren't interested in this sort of thing. They didn't want to form a branch.
I'm assuming that the definition of estate on page 851 is intended to work in the rules as well as in the Act, because of the way the Act is, if you like, a subsidiary of the rules. And that seems to contemplate that, in principle, estate includes any, let's say, hereditament, shall we? But where two or more estates, as so defined, are in the ownership of the same employer, the Commissioner of Police, on the application of the employer, may by order direct that any or all of such estates shall be deemed to be one estate for the purpose of this Act. So that, prima facie, unless the bank, by which I mean the legal person in this case, made that application to the Commissioner of Police and had it granted, then each little branch is actually a separate estate.
Premises. Yeah, that's right.
I mean, was any such application made in this case?
I don't think we know.
You may think this is going down a very deep rabbit hole, but in construing the extent to which the association is, as the tribunal thought, constrained only to act through a branch, one does need to think a little bit about how the branch concept works on the ground.
Yes.
It may be there was never more than one estate policeman or woman on each bank branch.
Well, maybe less than 5 anyway.
Yes, I see your Lordship's point.
I mean, if that application was made, then one can see that the branch concept that the estate concept would work quite well in relation to a particular major bank.
Yes.
But we don't, I think, know, do we, whether it was even done in this case?
No, so my Lord, to go back to the estate police rules, my Lord, back on page 669, just to complete the review of the rules. We then got at Rule 9, well, at Rule 8, I think Lord Legate's already pointed out, that's the provision for sending delegates to the Central Committee. And then Rule 9, a branch board constituted for a branch formed under Rule 3 may submit to the employer or the members thereof, or to all or any of the employers of the members thereof, any competent representation so far as compatible with Section 38 of the Act.
Yes.
That takes us back to that provision in the Industrial Relations Act. And then 10, the Central Committee may submit to all or any of the employers of members of the association any competent representation so far as compatible with Section 38 of the Act.
And that,
Well, that looks good
That
enough.
sends us right back to
like an
Section
either or.
38.
unless Section 38 provides to the contrary.
It does look like an either or.
Yes,
Yeah.
it is an either or.
Well-
They don't both have to.
No, but what I meant was, it doesn't look as if, at any rate, Rules 9 and 10 are saying that wherever there could be a branch, then the Central Committee can't do anything.
No, either could make a submission.
Yes.
If there isn't a branch board, then that won't operate, so it'll have to be the Central Committee. Unless it's incompatible with Section 38 for the Central Committee to do so.
Yes, but one needs to keep in mind that Section 38, what Section 38 is about, that's back on page 853, and that is bringing to the notice of employers matters which trade unions are competent to bring to the notice of employers of members of unions. So it's not quite the same thing as what we're concerned with, which is bringing to the attention of the minister the existence of a dispute.
Well, it's a pre-stage, isn't it?
It's what forms the dispute that is then referred to the minister, isn't it? You bring to the attention of the employer that there's an issue about terms and conditions or redundancies. The employer disagrees with you, and either party can then say to the minister, please refer it to the special tribunal.
Well, that would sit compatibly with Section 38, but Section 38 itself doesn't address that at all.
No, Section 40 does. 38 and 40, isn't it?
Section 40 is about disputes. Yes. That takes us back to the question of what's meant by a report by the Estate Police Association and what's required for that to happen.
I can't see anything in Section 38 which is incompatible with the Central Committee making a submission under Rule 10, I think it is.
Well, my Lord, what impressed the Special Tribunal in its decision was, as I read it, was which shall act through branch boards. And even if one takes the comma out and says it means which shall act through branch boards and a central committee, which, as we've seen from the rules, may be the right thing to do. It doesn't say which shall act through branch boards or a central committee if there isn't a branch board. In other words,
Well, what's the alternative? That it has to act through both simultaneously?
well, the alternative
The
is
rules
that
have to be, although the two rules give alternatives for the committee and the branch boards, they actually have both to operate concurrently in a given case, otherwise it's ineffective.
the alternative must be the Special Tribunal's view, which is that in the event that the state constables have not formed a branch board, then the thing doesn't get off the ground in the first place, because of the words shall act through branch boards and a central committee.
No, but what do those words mean? I mean, they either mean that you have to act through both, or they mean you may act through one or the other or both. Those are the only possible constructions, I think. And the idea that they have to act through both, otherwise any act they do is invalid, seems absurd, really.
Well, the argument, I think the argument that I can put on behalf of the Special Tribunal's reasoning, my Lord, is simply that this is inherently a collective process. There is in the Act and in the Estate Police Association rules provision for the creation of branch boards, and
But we don't know, I think, do we, whether there could have been any branch boards formed, not merely whether there were any. Because it's not within the constable's power to get estate expanded to include all the properties owned by a single bank. It's only within the employer's power to go to the police commissioner and ask for it to be done.
well, if that point has any relevance to the present case, which we don't know because we don't know what the numbers were. Let's suppose it's right for the moment that there had been no representation by the employer to amalgamate all of the different branches, all the different premises of the bank into one estate. We don't know whether that was a matter which had any consequence in terms of the ability or otherwise of constables to form a branch board. But
if they haven't done that, then the tribunal's construction puts it in the position that suppose there were branches all around the place for different constables, all with the same employer. They can't collectively act through the central committee. Each branch has to make its separate representations.
Well, the special tribunal's view seems to have been that what mattered was whether there had been a branch board constituted at all, because in the present case it was common ground that there was no branch board.
Yeah. Well, so if you have constituted a branch board, you don't have to act through it. You can then act through the central committee. That's even more ridiculous.
I think, as I understand their reasoning, it was the other way around. If you haven't constituted a branch board, then you can't take advantage of the provisions of the Act. And
that's not a very helpful outcome for a collective process that is intended to resolve disputes in relation to an employer of all the people under the same, say, terms and conditions or in the same redundancy round.
Well, one can see that objection, but one might make the same criticism of the legislation in regard to trade unions. If for example, there isn't a trade union which is formed in relation to a particular group of workers, then they have no rights to bring their disputes through the mechanism of the Industrial Relations Act.
But if there is a trade union, there's nothing, as my lady pointed out earlier, that requires you to act through the branch of the trade union rather than through the trade union's central committee. That's the equivalent. We've got an estate police association here.
Yes, but I suppose the difference, my lady, is that there is, as far as we know, in the case of trade unions, there isn't a provision expressly saying this is how they shall act. That's really what it comes to.
Have we seen all the materials yet before we get into the open field of ballot?
Yes, I think, my Lord, I think we have, but I'm grateful to your Lordship for raising the question. Other than I think the decision of the Industrial Court itself.
Well, you obviously want us to look.
Which I want to, by the Lordships, I think, and Ladyship ought to look at. It's page 534. I must say at once, as no doubt will have been spotted in the pre-reading, I can't claim an abundance of lengthy reasoning.
Well, it's one paragraph, I seem to recall.
Yeah, it is one paragraph at, it's really page 539. Paragraph 2. At the time of the retrenchment, which is the euphemism for them being sacked, the Estate Police Association had not established a branch board, which is a requirement under the Supplemental Police Act, in order that the association be able to represent constables of an estate.
Have they defined what they think the estate is? Or they do talk about it?
Well, they refer to Section 2, the Act, the provision that your Lordship looked at, or drew attention to earlier.
But they don't indicate whether it could have been one branch board or whether it would have had to be 20. How do they know it hadn't established a branch board?
I don't know, but I don't think that's one thing in the case which is uncontroversial.
Well, I know. I'm just wondering how they proceeded, though, because they raised the point, I think.
Yes. I don't know. It may be. I think maybe we can dig it out of the transcript somewhere.
They simply asked the representative of the association if there was a branch board, and he said no.
Right. And there was no, so far as one can see, there's no investigation as to what the relevant estate was in this case.
No. And as the board will see, they then set out the the set out provision of the Estate Police Association rules that we looked at shall act through branch boards and central committee. Party number one, the association admitted that the branch board was not in place at the time of the retrenchment exercise. That's reference to the interaction that my learned friend just referred to. And then they move on really to other matters.
So the key paragraph for our purposes is paragraph 2 under Tribunal's findings, is that right?
Yes. Because they then go on to talk about other aspects, and the estate constables not being workers and so on and so forth, and not being caught by the Retrenchment and Benefits Act. But as we've accepted in our printed case, that doesn't answer the question as to whether they had jurisdiction or not, whether they were right.
Well, if it were right, then they'd never have jurisdiction, I think.
Yes, that's right.
If the estate constables had to be workers.
Well, it depends. I think that depends upon a reading of the Retrenchment and Benefits Act. But in any event, the point that's live before the board is the jurisdiction point based upon lack of a branch board, and that's why you see you
say it's a jurisdiction point, but I mean we could call anything a jurisdiction point, but it's really a point about the standing of of one of the parties.
Where is the finding that the association had no standing?
Well, it's just the oblique statement in paragraph 2, I think.
Yes, there's no more than that. There's no explicit finding to that effect. But that's what it must, in substance, come to.
What, just the admission that there wasn't a branch board?
Well, and the requirement to be able to represent constables. It's not, they don't spell out what representation they say was relevant for this purpose.
Thank you.
No. So we see it, and we see at the end their assertion that
despite our interruptions, Mr. Rowe, you've taken us through all the relevant materials.
Yeah.
So it's. Have you also been able to make all the relevant submissions at the same time?
I think, my Lord, in the course of taking through the material and fielding all of your Lordship's and your Ladyship's very helpful questions, I respectfully say so. I think I probably said everything that can sensibly be said.
Well, thank you very much. I think we'll just rise for 5 minutes and see where we've got to. Mr. Mendes, as you've heard, we're not going to deal with the judicial review point at all. And having heard Mr. Rowe's valiant submissions on the branch board point, we don't consider we need to trouble you with a reply submission on that either. But if you've come a long way, and if there's anything you're anxious to say that we should think about or include in our reasoning, then now's the chance.
Well, I'm happy that I came because I like to be in London and I enjoyed myself.
Well, it's a delight to see you.
But if there's just one thing by way of clarification, Lady Rose has asked a question about trade unions normally being required to act through branches. There's no provision like that under the Industrial Relations Act. Under Section 51, that my learned friend referred to, reports of trade disputes are made primarily by the employer or the recognized majority union, or where there is no recognized majority union, any trade union, which has the workers...
Which page are we on?
That's page 734.
734.
And the recognized majority union is described under the Act. There's a process that a trade union has to go through to become recognized. There has to be established a bargaining unit, which is defined and determined by the recognition board, which is a separate body established. And then the union must demonstrate that it has more than 50% of the members of the bargaining unit as its members in good standing. It then becomes recognized. And as a recognized majority union, it acquires certain rights, and the employer has certain obligations in relation to the recognized majority union. But where there is no recognized majority union in relation to the bargaining unit, then any trade union can make reports of trade disputes to the industrial court, well, through the minister, first of all. The role of the minister is to attempt to conciliate. If that conciliation fails, then the dispute is reported to the court. And in subsection 5 of section 51, there is a limitation on the types of trade disputes that the non-recognized majority union may report to the court. But there is no requirement under the Act that you act through branches. But of course, trade unions have branches, and it would be part of their own constitution.
There does have to be the bargaining unit.
That's correct. Yes.
And a bargaining unit can extend across different premises.
Well,
it's usually has to have common terms and conditions of employment.
It would, because once the recognized majority union negotiates terms and conditions in a collective agreement, it applies to everyone in the bargaining unit, whether or not you're a member of the union.
Yes.
And the bargaining unit will not be defined by reference to geography. It will be defined by reference to function or how they are paid, whether monthly paid or weekly paid, as the case may be. But that is all determined by the recognition board.
But can I just clarify? If there's a member of the union, but there's no, and the union is recognised, but that member of the union is not part of a bargaining unit, how then, if a dispute arises in relation to that worker, how then does that case get before the industrial court?
Then any trade union can report the dispute to the industrial court. If there's a bargaining unit that is defined, but the worker is not in that bargaining unit, then the union that is recognized in relation to the bargaining unit can report the dispute in relation to that worker who is not a member of the bargaining unit. Right. But then any other trade union can also report that dispute. The recognized majority union has exclusive authority in relation to the bargaining unit. Right. Once there's a recognized majority union, no other trade union can make a report. But of course, none of that applies to the Estate Police Association, because it has exclusive authority under the Supplemental Police Act to represent all estate police officers, police constables.
But I think what I was thinking was if the special tribunal and estates constable mechanisms are supposed to be analogous to how trade unions work with other employers, then if it was clear, for example, that there were quite strict restrictions on how a trade union could bring a claim for a member before the industrial court, one might say, well, perhaps that's what's being reflected in this requirement that they shall act through branches.
Well, it's clear that there's no requirement that you have to have a recognized majority union. There's no requirement that you have to have a bargaining unit established by the recognition board. In the absence of a bargaining unit, in the absence of a recognized majority union, any trade union can make a report, as Section 51(1) says, but the disputes that they can bring are set out in Section 51(5).
Thank you.
Yes, thank you very much indeed.
Thank you very much.
Well, thank you. Nothing you want to add to that, I imagine, Mr. Rowe?
No, my lord.
Thank you. Well, we're most grateful to Council for their very sensible and helpful written cases and for the realistic submissions that have been made this morning. The board will take a short time to consider its judgment in this matter and will promulgate it in due course.